Hello, listeners. Welcome to a new episode of the ENSign podcast. We're dealing with dispute resolution today, specifically international arbitration and how awards are enforced. Today's guests are Joseph Konadu and David Adu-Tutu Jr., both of them disputes partners at ENS Africa, Ghana. Gentlemen, welcome.
Thank you, David.
So let's jump right to it with, I guess, an introductory question. What is an international arbitral award? Who will take it? I'll leave it to you, gentlemen, to decide who will take it.
Joseph, I can take a first shot, and then you can add any comments. Is that okay?
Yes, please.
Okay. So David, an international arbitral award is basically an award which is made in country A and sought to be enforced in any other country other than country A. So if an award is made in the UK, South Africa, Nigeria, Jamaica, or any other country, and sought to be enforced in Ghana or any other country apart from the country in which it was made, then the award is considered international for the purposes of the enforcement.
Just to add to the answer, David, Ghana has a very interesting way of describing international awards. So in our law, international awards or awards that weren't made in Ghana are called foreign awards.
All right, then. So
Yes,
are we
that's
saying
correct.
that we might be interchanging those two terms, foreign award and international award?
Yes, please. In some sense, an international award may be slightly different from a foreign award, because any award, if there's an award in Ghana and it's between two companies incorporated outside of Ghana, one would presume that because the award deals with multinationals, it's an international award. But because if it was made in Ghana, it may be classified as a domestic award. So for the purposes of enforcement and the like, usually the terminology used is foreign to show that it came from outside of the physical barriers of borders of Ghana. Yes.
Thank you.
And David, if I may just add that
Sure.
under Ghanaian law, the definition of an international award as under the New York Convention, which is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958. The definition of an international arbitral award there has been adopted under Ghanaian law, under the first schedule to our Alternative Dispute Resolution Act.
This brings me to the next question. Why do or would a foreign arbitral award have to be enforced in Ghana? Why?
Lisa, would you want to go first?
Sure, David. So, David host, there are several reasons for people to seek to enforce international stroke foreign arbitral awards in Ghana. One of the key reasons people do this is because the defendant or the person who lost in the arbitration may have assets in Ghana. And with the legal or judicial system, you can't just get up and come and take a losing party's assets just like that. You have to go through the judicial authorities in the country. And it's for this reason that if you have an award which was made outside of Ghana, you would present it to the judicial system in Ghana for it to be recognized, and then you can chase the assets of the person who lost in the arbitration. So that's one of the main reasons people seek to enforce foreign awards in Ghana.
So if I may add to that, basically an award of any kind, whether local or foreign, is really a private agreement between parties to submit to the jurisdiction of a chosen arbitrator or institution. The award itself does not have the backing of the courts or any system of enforcing awards or judgments. So you need the permission of the courts to use the court systems and the court processes, and basically the backing of the state to be able to enforce such an award. So in the case where especially in the case where the award is coming out of the country, there are jurisdictional issues, there are, like Joseph mentioned, there are barriers. You don't just get into another country and start waving your award in the air. You need to make sure that it conforms with the laws of the country that you're seeking to enforce them in. So you need to register it, or you need to get it adopted or recognized by the courts of that local country so that you can enforce them.
All right. Let me move this on to the next question, the third question. What are the steps to take, or the steps one must take to enforce a foreign arbitral award in Ghana?
So taking this one, there are two steps, but they are rolled into one. So it's a two-pronged step. You basically bring the award to the attention of the Ghanaian court and ask the Ghanaian court to recognize the award as if it were a judgment of the Ghanaian court. And once the award has been recognized, the court will give you permission to enforce the award in Ghana as if it were a judgment of the Ghanaian court. So once the award is adopted, the court will give you permission to use its systems and the backing of the states to ensure that the award is complied with. So broadly, those are the two steps. Just to add to this, the process of bringing the award to the attention of the courts is by basically applying to the courts to say, we had A and B had an agreement. The agreement had an arbitration clause, which required that disputes should be submitted to this particular institution or this system of ad hoc arbitration. There was a dispute. The dispute was referred properly, and there has been an award. So that's practically what you're telling the court. And there are a few things that you need to bring to the attention of the court when you are making this kind of application or request. And I'm sure we'll come to the practical challenges or some of the practical things you look out for. But the application itself has to demonstrate to the court that the award was made by a competent authority in the foreign country, that the foreign country has an arrangement with Ghana in which judgments in the foreign country are recognized in Ghana, or awards in the foreign country are recognized in Ghana, and awards from Ghana are also recognized in the foreign country. That's one option. The other option, so this is one option. The other option is to say that, or show to the court that the award was made under the New York Convention or any other international convention on arbitration which has been ratified or accepted by the Ghanaian Parliament. In that application, you need to show the court the original copy of the underlying agreement, which had the arbitration clause, or an authenticated copy of it. And you also need to show the courts that the arbitral award, an original copy of the arbitral award. There are other conditions, but I think we can discuss them under the next.
Thanks, David. So in our discussion prior to this recording, you both made me understand that there were some practical or peculiar pitfalls that a party wishing to enforce a foreign arbitral award in Ghana must look out for. So can you tell us about some of these pitfalls and traps, which you won't necessarily find in, I guess, the law or the statutes, but exist on the ground?
Okay, David. So I'll take a first go. I'll probably premise my answer by saying, generally, within international arbitration circles, there's this notion that big multinationals who are used to arbitration would usually respect an arbitral award. And so most international awards get respected and carried out by the parties without a need for enforcement. However, if you have the need to enforce, it means that the other party is significantly dissatisfied and doesn't intend to comply with the terms of the arbitral award. So clearly, such a party would do their best to put impediments in your way in getting the award enforced. That was just the premise I wanted to set before we go into the answer. And for this reason, a lot of parties who lose arbitrations would try and rely on technical basis or reasons to convince a court in Ghana not to recognize and assist in the enforcement of an arbitral award. And there are certain key factors that a successful party and their lawyers should take note of, because we see happen in the Ghanaian courts often. The first one, and David panelist mentioned a few minutes ago, is that you need to present certain documents to the court when you are seeking the court's help to enforce an arbitral award. And one of it is the underlying agreement, the agreement which based on which you went to arbitration. It's very important that you present what the law calls an authenticated copy, which is simply a copy which has been certified by the right authority in the country in which the award was made. So let's say you had an award from the United Kingdom and you want to enforce it in Ghana. A lot of people forget that whatever document you place before the court should have been certified by the right person from the United Kingdom. Otherwise, you're going to face a challenge. Secondly, you need to present an original or, again, authenticated copy of the award. So, for example, you can't just print a soft copy of the award and present it to the court. You either have to present an original copy or you get the issuing body to give you a certified copy and you present that to the court. And this is about presenting documents. Again, some losing parties using local lawyers will raise some technical challenges like stamping. So you've won your award, you are happy, you presented documents in the award, you were accepted, you come to Ghana, and you present the same underlying agreement. The other side can raise the issue that the document is not stamped. And under Ghanaian law, every document that is being used in a court process should have been stamped and the right stamp duty paid. And so that is another thing that parties and their lawyers, successful parties and their lawyers, should check. You must make sure that the documents you are presenting to the court, especially the agreements, have all been stamped in accordance with Ghanaian law. I would mention a final issue, and I'm sure David panelists will come in again. And this is about the state of Ghanaian law itself. When you look at the law that guides this process of enforcement, to us lawyers, it may look clear, but just like everything that lawyers deal with, they end up not being clear when we have to apply them. So there has always been this question about awards coming from countries with which Ghana, who are parties to an international agreement called the New York Convention, automatically enforceable by Ghanaian courts. And the way the law is drafted, the answer should have been a simple yes. But in practice, because of some drafting challenges, people raise technical objections and say that beyond the award coming from a country that has signed on to this New York Convention agreement, Ghana should also have a reciprocal arrangement with that country. Our own view is that you don't need to have the award coming from a reciprocal country, but we've seen judges actually agree with the other position and refuse to enforce awards. So parties should also be very careful of this challenge, so that if you have a choice in choosing where to have your arbitration, maybe you should be looking at a country that is not just signed on to the New York Convention, but has also entered into a reciprocal arrangement with Ghana. So these are some of the things I would like to mention. Thank you, David.
Thanks, Joseph. David Jr.
Yes, I think Joseph has covered this very succinctly. Maybe just one more point I will make, that under the law, the party seeking to enforce the award has to demonstrate to the court that the unsuccessful party was given sufficient notice to present its case during the arbitration. So as a practical step, especially in arbitrations which are one-sided, where probably the unsuccessful party did not take part in the proceedings or decided not to at all, apart from, besides presenting the original award or the authenticated copy of it and the original agreement or an authenticated copy, it's important that if there are any procedural orders that were made in respect of notice, so that, for instance, if the request for arbitration was served, evidence of service is important to bring it to the attention of the court. If there were any procedural orders that were made, which made statements around service being made and the party choosing not to partake, all these should be brought to the attention of the court so that the court is aware that there was sufficient notice given to the other side, so that the other side cannot raise a procedural objection at the time of applying to enforce or adopt and enforce the award.
All right. That was quite a bit in terms of practical things to know about enforcing foreign arbitral awards. My final question is, sometimes we've just been talking about foreign arbitral awards. Sometimes you hear about foreign judgments, and I'm quite certain there's a reason there are foreign judgments and foreign arbitral awards. What are the main differences, or what's the main difference between a foreign judgment and a foreign arbitral award? And in enforcement terms, I guess the follow-on question is the difference important or significant? Again, I'll leave it to either of you to answer.
So, David, I'll take a first shot at this, and then Joseph can come in. So, foreign judgment, the law draws a direct distinction between foreign judgments and foreign awards. Foreign judgments are judgments that are coming from courts of competent jurisdiction in other countries, whereas foreign awards are coming from an arbitral institution. And the procedure for recognition and enforcement is also totally different. Joseph has mentioned that there's a law that specifically guides the enforcement of foreign arbitral awards. That law is different from the law that guides the recognition and enforcement of foreign judgments. And the conditions to be met, although similar, are quite different as well.
Thanks, David. Joseph?
Yes, David, and I'll just add that the kinds of, if you like, orders or benefits under the judgment or the arbitral award that can be enforced in Ghana are also some of the differences that you would see. So, for example, when it comes to arbitral awards, from the way the law is crafted, it seems any kind of order can be recognized in Ghana and have effect. But when it comes to foreign judgments, we are a bit more restrictive, maybe partly because that's judgments from a court represent the exercise of a state's power, and we don't want to be enforcing another state's power within our own setup. So you find that for judgments, it is usually for money judgments. And then what we call maintenance orders. If a court says a parent should pay money to another parent for the upkeep of a child, it's basically just payment of money that can be enforced through the enforcement of foreign judgments. But when it comes to arbitral awards, once the award contains certain reliefs or certain benefits to one party, usually the entire award would be recognized and you can get the benefit in Ghana.
Yes, and just to add to that, into a bit more detail, even for money judgments, it's not all money judgments that are enforceable, especially if the amount to be paid under the foreign judgments is in respect of taxes in the foreign country, or any other charges of a similar nature, like a fine or a penalty, the Ghanaian law does not permit such a judgment to be enforced in Ghana. So that, for instance, if a party A is found to owe tax liability in a foreign country, the law will not permit the judgment or any judgment to that effect to be enforced against party A's assets here in Ghana. And I think it goes back to Joseph's point about the exercise of state power or state sovereignty, where Ghana would not want other countries to be exercising or extending their sovereignty into the states, just like that. So that's an addition to the points that Joseph made. And there's also a difference in terminology, even though it's not material. So for an award, we call it the recognition and enforcement. For a judgment, a foreign judgment, the process is called a registration, where you apply to get a judgment registered under Ghanaian law. Even though for non-money judgments or judgments that cannot be enforced by registration, the procedure which Joseph has taken us through, they can still be recognized by the court in other ways. And that usually is if party A has a judgment against party B in a foreign country and a dispute arises in Ghana concerning the same issue that was determined in that judgment in the foreign country, party A can bring the foreign judgment to show evidence that the issue has been determined, and this is the position as between the two parties, and the courts will recognize that judgment and then make a ruling on the basis of it. So the judgment itself will not be enforced as if it was registered, but the court will recognize it and give a judgment on the basis of it. So that's another distinction.
Thank you. I guess we can call it a wrap here. We're running out of time. So thank you very much, David Adu-Tutu Jr. and Joseph Konadu, disputes partners of ENS Africa Ghana, for joining us on the ENSign podcast today.
Thank
Listeners,
you, David. That was fun.
you're
We should do
welcome.
it again.
Absolutely. Listeners, thank you so much
David,
for joining us. Thanks, David. Thanks, listeners, for joining us on another episode of the ENSign podcast. Please be on the lookout for the next episode coming soon to you. Till we come back to you, it's bye.